Lobbyist Bundling Disclosure Rules, an FEC Roundtable workshop recorded on April 29, 2009.
As Greg mentioned, I'm Liz Kurland, and I'm going to start off the presentation on the Lobbyist Bundling Disclosure Rules. And these new Lobbyist Bundling Rules are, as I mentioned, they're disclosure rules, meaning that they may require additional reporting by certain committees. And that first such report is coming due in May, which is the reason that we're holding this session today, because at this point we have not received any Lobbyist Bundling Disclosure reports, but in May will be the first possible reports due. And so what we're going to do in our session today is we're going to first explain the new Lobbyist Bundling Disclosure Rules. Okay, so explain how the rules work and who is required to file additional reports under these rules. Then we're also going to define some new terms that were created by these rules. As Greg said, these rules are a little bit different than some of the existing rules, and as such created new terms. New terms such as bundling, that is a brand new term under our rules. Also the term covered period and the definition of who is a lobbyist. And we're going to go over those new terms to help you understand how these rules work. And then we're going to outline the filing deadlines, and we're going to do that by type of committee. As disclosure rules, of course, then there are additional reports that could be due. And when those reports are due depends on the type of committee who is filing the disclosure, whether it's a campaign, whether it's a party, whether it's a PAC, and whether they file quarterly versus monthly. And we're going to talk about all those deadlines again by committee. And then we're going to round out the session by going through a fundraising event scenario. And we're going to go through that scenario. Actually, Debbie's going to lead us through that scenario. And we're going to determine the proper disclosure as a result of lobbyist bundling activity at a fundraising event. Okay. Now, one note I want to put out there at the beginning is that keep in mind that these are brand new rules. So the source documents we have for these rules are simply the statute, the regulations, and the explanation and justification for these regulations that were published in the Federal Register in February. And that's it at this point. So Debbie and I will do our best to answer any questions that you have that may not be specifically addressed by the regulations. But keep in mind that certain issues may not have been addressed yet and may be right for an advisory opinion to the Commission. And just as an aside, what an advisory opinion is an opportunity for someone to ask for advice from the Commission on a proposed activity. So it's possible if there's an answer that Debbie and I can't answer, you may want to request an advisory opinion to get the Commission to give you formal guidance on certain lobbyist bundling activity. Okay? Okay, before I get started, I just want to note what is in the folders that were on your chairs when you walked in. Not only is there a copy of the outline and the slides that we're using today, but also is some of those source documents I talked about. The Federal Register notice that was published in February that includes the final rules and the explanation and justification, or what we call the E&J, explaining how the Commission came to those rules. So those are in your folders for future reference. Also is the FAQ, which is also found on our website. We do have a separate section for lobbyist bundling activity on our website, which includes some of these source documents, but also an FAQ, some frequently asked questions that have some answers right now. Also is Form 3L. We're really going to focus on this new disclosure form later in the session, but this is the form that was created by the Commission to disclose lobbyist bundling activity. So it's not going to appear in the Form 3X or the Form 3, the committee's file. It's a separate form specifically for lobbyist bundling disclosure. Okay, so you have a copy of it, and I'll be referring to it a little bit during the session. So just keep in mind that you have that in your folders. Any questions that anybody has before we get started? Okay. So what we're going to do first is just give you a brief explanation of the new lobbyist bundling disclosure rules. Now, these rules implement the statute that I mentioned is the Honest Leadership and Open Government Act of 2007, or what's often called HLOGA. And that was signed into law by President Bush in September of 2007. And the section of the statute that covers lobbyist bundling activity is Section 204. And the purpose of that section was to create additional transparency of bundling activity. So it's not intended to prohibit what's considered bundling activity, but to now have disclosure of this kind of activity that has been going on with lobbyists. Okay, so keep that in mind. It's not a prohibitive section. It's really to encourage disclosure and transparency. And what these rules do is they will require campaign committees, and that's House, Senate, and presidential campaigns, party committees and leadership PACs to disclose certain bundled contributions from lobbyists, registrants, and lobbyist-registrant PACs. Okay, so that's the basic of what this disclosure rule is. Now, these rules have just recently gone into effect, but there are actually two sets of effective dates. So let's go over those briefly. First set of effective dates concern the record-keeping requirements under these rules. Okay, so the campaigns, parties, and leadership PACs who receive bundled contributions were to start keeping records of those bundled contributions starting March 19th if the bundler was an individual registrant or lobbyist, or if the bundled contribution was received from or credited to a lobbyist registrant PAC, those campaigns, parties, and leadership PACs needed to start keeping records on April 18th. And those dates are derived from the publication of the rules in the Federal Register. It's basically 30 days after publication and 60 days after. Okay, so that's the first set of effective dates concerning record keeping. The second set of effective dates concern the disclosure. As I mentioned, there hasn't been any disclosure yet, and the reason is the first possible disclosure will be in May, because the effective date for disclosing lobbyist bundling activity is for reports due on or after May 18th. And as you'll see later in the session, generally the Form 3L, or the lobbyist bundling disclosure, is going to be filed with regularly scheduled reports by campaigns, parties, and leadership PACs. And the first report due after that May 18th deadline is the May 20th monthly report. Okay, so we're going to talk more about those reporting deadlines later. Okay, so again, that's kind of the general information about these rules. Now, before I continue, we want to define one of our first new terms, and that first new term is reporting committee. And as the name indicates, the term refers to the committees who are required to report under these lobbyist bundling disclosure rules. And those are the campaigns, parties, and leadership PACs. Okay, as such, as you see, separate segregated funds are not listed there. That's because SSFs do not have to file any disclosure of lobbyist bundling activity. Okay, so it's only for campaigns, parties, and leadership PACs.